Hello everyone, this is Stuti Khare from Institute of Law, Nirma University and interning under the Amikus Qriae. Today I'll be briefing you all about the constitutionality of death penalty. Death penalty is also known as capital punishment, and it is the highest degree of punishment that can be awarded to an individual under any penal law in force in any part of the world. Capital punishment is the legal procedure of the state in which it exercises its power to take an individual's life. Under the Indian Penal Code, discretionary death penalty is prescribed in two patterns. The first pattern has very wide discretion, is vested in the courts to choose from death sentence and a wide range of another lesser sentence. The second pattern has only a limited discretion available to the court to choose from the sentence of death and single alternative like imprisonment. Where the law provides for discretionary death sentence to courts, the constitutionality of death penalty becomes a debate. So we'll be discussing various laws regarding the same. The first case is Jagmohan Singh versus State of UP. This was the very first case dealing with the question of constitutionality of death penalty in India. The Supreme Court held that it is not violative of Article 21. There exists a procedure, and the procedure is a fair one, and under this, the accused is given utmost time to prove his innocence. Because of the process, the state snatches the life and liberty, therefore, death sentence was held to be constitutional. The second case was Ediga Annamma versus State of Andhra Pradesh. Here, Justice Krishna Iyer commuted the death sentence to life imprisonment by citing factors like age, gender, socio-economic background, and psychic compulsions of the accused. It was laid down in this case that apart from looking into the details of the crime and deciding based on the extent of violence committed, the judges should also look into the criminal intention and his condition of or helplessness while committing the crime. The third case is Rajendra Prasad versus State of Uttar Pradesh. Here, circumstances under which death penalty could be imposed for the offense of murder were discussed. Death penalty should be imposed only in those cases where the criminal was beyond a chance of reformation. It should be imposed if public interest, social defense, and public order is damaged. Section 354, Clause 3 was added to CRPC after the case, which made death penalty an exception as opposed to the previous situation. The fourth one is Bachchan Singh versus State of Punjab. Here, the Supreme Court ruled that death penalty can only be applied in rarest of rare cases. It is stated that the judges should give special reasons for awarding a death penalty, and it should not be awarded in every case. It was held that the mandatory requirement of pre-sentencing hearing should be introduced in the CRPC, which made it necessary not only to consider the circumstances of the crime but also that of criminal. The next case is Machi Singh versus State of Punjab, in which it was described that what all cases fall under the rarest of rare category. If there is something uncommon about the crime, life imprisonment is inadequate even after considering the mitigating and aggravating circumstances, then they fall under the rarest of rare cases. Also, the manner and motive for commission of murder, socially abhorrent nature of crime, magnitude of crime, and personality of the victim of murder were also some criteria laid down to elucidate the rarest of rare rule. In Mithu Singh versus State of Punjab, the view on mandatory death penalty was given. Section 303 of IPC was held unconstitutional in this case. If a person is already serving for life imprisonment for a murder and commits a murder again while serving the punishment, then the court would have to mandatorily award a death penalty on that person under Section 303 IPC. So this section was held violative of Article 14 and 21 as it creates an unreasonable distinction. In Alauddin versus State of Bihar, it was held that unless there are special reasons special to the facts of the particular case, which can be catalogued as justifying a severe punishment, the judge would not award the death sentence. It may be stated that if a judge finds that he is unable to explain the reasonable accuracy The basis for selecting the higher of the two sentences, his choice should fall on the lower sentence. In Dhananjay Chatterjee versus State of Bengal, West Bengal, the court was of the opinion that it is not possible to lay down any cut and dry formula relating to imposition of sentence, but the object of sentencing should be to see that the crime does not go unpunished and the victim of crime as well as the society has the satisfaction that justice has been done to it. In Ravji versus State of Rajasthan, it was held that the nature and gravity of offence and not the criminal were germane for consideration of appropriate punishment in a criminal trial. The punishment must be consistent with the atrocity and brutality with which the crime is perpetrated, the enormity of crime warranting public abhorrence, and it should respond to the society's cry for justice against the criminal. In Satish Bhushan Beriyar versus State of Maharashtra, it formulated a two-step test to determine whether a case deserves the death sentence. Firstly, that the case belongs to the rarest of rare category, and secondly, that the option of life imprisonment would just not suffice and the convict is not fit for reformative or rehabilitation scheme. In Sangeet versus State of Haryana, the Supreme Court commuted the death sentence to life imprisonment and observed that the aggravating circumstances pertained to the crime, while mitigating circumstances referred to the criminal, which are distinct elements and are incapable of being compared. Where there is uncertainty as to the propriety of punishment, awarding of life imprisonment does not stand unquestionably foreclosed. And the case of Sunil Dutt Sharma versus N-City of Delhi, it was held that in fixing the degree of punishment or making the choice of sentence for various offences, including one under Section 302 of IPC, the court should not confine its consideration principally or merely to the circumstances connected with the particular crime, but also should give due consideration to the circumstances of the criminal. All in all, in the view of our discussions, we can see that India's thinking on capital punishment is still quite muddled up. It is not just a debate of legality and constitutionality of the death penalty, but also the moral and social aspects that are related to this controversial topic that have to be led to extensive confusion in this respect. Maybe there is no real right or wrong answer to the issue of capital punishment. What is required is careful examination of facts and evidence by the judiciary in every such sensitive case to avoid any possibility of error. Also, India lacks an authentic statistical database of the number of convicts being sentenced to death and executed in relation with various other factors which would give us clearer picture of what needs to be done ahead. Thank you.